Respected Chief Justice, sir, honorable judges, and my dear friends. I'm going to focus today on patent litigation in the context of pleadings in the context of patent litigation. But before I get there, I wanted to share with you a mantra, a general mantra which a professor of mine in law school, he was an eminent trial court lawyer in Chennai. He was a visiting faculty, and he told us something that has stayed with me for a long, long time, and that is simply this. When you draft a case, when you draft an application, please look at the section. The section is actually screaming at you the ingredients of the pleadings. So please always have the ingredients of the procedural section or the order or the substantive law always in mind. Glean or distill the ingredients of the section and make sure you have averments supporting those ingredients. That is a very, very important mantra to keep in mind. The other point that I wanted to make is with respect to the prayer. What I've noticed is that that's really sometimes an aspect of a document in court that gets the least amount of attention. Make the prayer extremely precise, because what happens is that when the order is dictated, because it is so verbose, because it contains so many other unnecessary details, the crux gets lost, and sometimes you end up getting an injunction which is completely inadequate. I also want to share with you two practical solutions which have resonated with me. The use of, for example, slide decks in oral submissions. And this is extremely important, and I found it very, very useful, especially when arguing a patent infringement case, which is so technologically intensive. And what I've noticed is that when you present a judge in advance of your arguments with oral submissions contained in a slide deck, the judge is able to focus on your oral submissions rather than taking notes. And this is particularly rewarding in a patent proceeding, is what I found. And the other is that we all have synopses in the plaint and various other documents that we file. But what if we can also have, for example, paragraph referencing or page number referencing in the synopsis itself? Because what I've heard from a lot of judges is that because of the volume of cases they handle every day, it is really that synopsis that is read. And if you can therefore have paragraph numbers or page numbers in terms of cross-referencing, I think would be very, very useful for a judge to quickly look up where you have actually pleaded or you have supporting documents with respect to that particular aspect of the synopsis. Now, coming to plaint averments, unlike a trademark dispute, in a patent dispute, one doesn't really need to wax eloquent about who the plaintiff is. So keep it very, very basic. As far as the description of the invention is concerned, this is really a critical area, the heart of the plaint. A patent document, as you may all know, is a very complex, technologically intense document. So break it up, make it simple. Every patent, as you know, contains an invention which is really a technical solution to a technical problem. So state in the plaint what the problem is that the patent or the invention is addressing. That simplifies everything for the judge. Talk about the prior art so that the judge gets a complete context as to what the invention is all about. The prosecution history is another very critical aspect of the plaint. So for example, if there are pre-grant and post-grant oppositions, please do mention them, because that would give the judge or the court an indication about the strength of the patent, the credibility of the patent. Another very critical area is the status of corresponding applications, foreign patents or foreign applications. This is most crucial, a disclosure with respect to refusals, rejections or revocations of the corresponding patent in any other jurisdiction. We recently had the Freebit case where on day one, an interim injunction application was dismissed. Please do read the Freebit case, because that was a case where orders and details with respect to previous refusals were not placed on record. That was a case where the Form 3 filings pursuant to the Section 8 obligations of keeping the Patent Office abreast of developments with respect to corresponding patents in other parts of the world, there were inaccuracies in the way those Form 3s were submitted. So file your Form 3s so that the court gets a complete perspective. The other side does not get an opportunity to say that the Patent Office was misled or that the plaintiff made any effort to hide anything. Also devote a paragraph to the working of the patent. This is crucial, especially if you're dealing with a patentee who doesn't work the patent himself, doesn't manufacture products himself or herself. You need to show that the patent is being worked in the form of licenses granted. This would be an important consideration from the point of view of balance of convenience and irreparable loss. So please do have a paragraph dedicated to the working of the patent. File your Form 27s. I'd like to focus on two, which is the relationship between the plaintiff and the defendant, if any. So for example, if there has been a past licensing arrangement between the plaintiff and the defendant, please do elaborate on that, capitalize on that. Because the law after Nokia versus Oppo is that if the licensee, if the plaintiff and the defendant have had a license or licensee relationship with respect to the same family of patents, then a prima facie case of infringement is made out. So please do dwell on the a relationship that may have been there between the parties, if that is indeed the case. Serial number 3 is again crucial. This, for me, is the heart and soul of a patent suit or a patent plaint. As you may all know, patent infringement occurs when the critical integers, the dominant integers or elements of a claim, find incorporation in a defendant's product. So as a plaintiff, please do identify what the essential elements or integers of the claim are. This is very, very crucial. And then map these integers or elements to the defendant's product. Now, there may be some elements which are not identically relatable or correlatable or mapped. For example, there may be equivalence in terms of elements that are used. In cases such as those, please make sure you satisfy the requirements of FMC versus NATCO, which is that you have to plead that that element in respect of which you are asserting equivalence is substantially for the same function in substantially the same way to yield substantially the same result. So pleading, especially in a patent case, because it is so fact intensive, is very, very critical. 4, pinpointing the time when you gain knowledge of the defendant's activities. And then, what did you do subsequently? My advice would be that, considering that our courts and most courts in this country don't grant ad interim relief in terms of injunctions in a patent infringement case, as soon as you become aware of an infringing activity, please proceed to issue a cease and desist letter so that your time starts ticking. And that is because damages calculation would have the time period for calculation of damages would be from the time when the defendant was actually notified of your rights. So please do not hesitate to issue a cease and desist letter. The general feeling is that if I issue a cease and desist letter, I won't get an ex parte order. But in a patent case, you're anyway not going to get it. So you might as well strengthen the damages component of your case by issuing that cease and desist letter. I thought I must spend maybe a couple of minutes or a minute on claim mapping. In a non-SCP case, you would map the integers or the elements of the patent claim to the defendant's product. In a SCP situation, which envisages an indirect method of proving or establishing infringement, it is possible to establish infringement by mapping the claims onto the standard, establishing that there are elements in the standard which find incorporation in the claims and vice versa, and then compare and establish that the defendant's product also incorporates the standard. So as far as the written statement is concerned, as far as non-infringement is concerned, take a categoric stance with respect to whether there is or has been infringement or not. Identify what, according to you, are the essential integers and map it to the claims to show that one or two or three of those integers are missing. In the alternative, it is possible for you to say you're using an alternate technology, and if so, state it. And my experience has been that judges become most comfortable when a defendant is able to say or state what technology they're actually employing if their case is of non-infringement. So please do consult your clients with respect to what alternate technology you can plead, notwithstanding the fact that in a product patent infringement case, it may technically not be the obligation of the plaintiff to say so. But just from the point of view of having the judge with you, I think this could be invaluable. I thought no presentation would be complete without the role of AI, as Mr. Anand mentioned. There are pros and cons. AI obviously cannot advise on litigation strategy. We all know how capable it is of hallucinations and breach of confidentiality. But there are several advantages. And as Mr. Anand said, I think it would be extremely negligent of us in this day and age not to use AI. It is a fantastic tool which we must all embrace. But as far as drafting advice is concerned, a lot of these courts at some point today have already found mention. But here are my 5 cents. Take pride in your work. Very, very important. Make sure there are no grammatical mistakes, punctuation mistakes, spelling errors. Very, very critical. and nothing which is glaring. You may make an error of judgment as far as law is concerned, but not in the way you put it. So take pride in your work. Keep it simple. Don't use complicated words or language. And of course, keep it brief and concise. Thank you very much. It's been an absolute privilege to be here.